Hey guys, Ryan Reiffert here with another video. Today's topic is whether a contract must be in writing in order to be enforceable. I get this question from time to time, and it has a simple answer and also a slightly more complicated explanation attached to it, so I figured I'd make a video. Before we get any further, go ahead, drop a like and subscribe, send a comment, send a message if there's some other topic that you want to see. But otherwise, go subscribe and click the little, no, it's over there, it's that way, the little bell. So let's get into the topic today, which is, does a contract have to be in writing? Does it have to be an actual physical paper legal document that is signed? Must it be in writing in order to be enforceable? The quick answer to that question is no, it does not. An oral agreement is enforceable. A handshake agreement, an agreement that is solely oral, solely verbal between the parties, can be enforced as a contract. In fact, there's a very famous case that had to do with this, which was the Joe Jamale, Texaco, Pennzoil, Getty Oil mess. This happened in the early 80s. I want to say maybe 1983, 1984, somewhere around there. And that case was out of Houston, which kind of really was Joe Jamale's sort of coming out party as becoming a gigantic Titanic force on the Texas legal scene. And the question in that case was whether a non-written, non-signed agreement between the parties could be enforced. There was a verbal deal between Getty and Pennzoil, and to give you a little bit of the background, we won't get too much into it, but Pennzoil had been having some difficulties with reserves and that sort of thing. Getty had tremendous proven reserves, so Pennzoil wanted to acquire Getty for price of X dollars. Well, Getty had kind of put itself on the market, right? And Pennzoil was not the only suitor that Getty had. So once Pennzoil and Getty kind of announced their deal, Texaco swooped in and made a superior offer, which the board of directors of Getty went ahead and accepted. Following which, Joe Jamale sued Texaco on behalf of Pennzoil, saying that they had caused the contract to be broken, and he was seeking damages. Ended up winning 10.3 something billion with a B dollars. See, there you go. I was exactly right. $10.53 billion for the total overall verdict, which actually after interest ended up coming up to 11 point something billion, which is a little bit of walking around money for you. So that's your famous case, your kind of Pennzoil versus Texaco, which again was very notable because it's somewhat unusual for the major oil companies to really kind of go head to head like that. But there it is. Now, you should not interpret this to mean that you're cool to go around and make all kinds of non-written agreements, right? There's a couple of caveats attached to this, and which is why I say that the answer is a simple answer, but also has a kind of more complicated thing attached to it. So, first point, there is a law called the Statute of Frauds, which originally comes back from merry old England back in the day, hundreds of years ago, yada yada, and has been adopted by most states of the United States. And basically what that says is there are certain types of deals, there are certain types of transactions, there are certain types of contracts that must be in writing. So, for example, sale of land, or a contract that cannot be performed within 1 year, or that sort of thing. There are laws on the books in many states that say that those contracts must be in writing. It's called the Statute of Frauds. And the original deal for that was the original justification rather for that was related to the second point for this, which is that even if your agreement could technically be oral, even if your agreement could technically be an unwritten contract, it's still a very good idea, just as a matter of prudence and just as a matter of good business practice, to put those things into writing. And there are a few reasons for that. One is, of course, the evidentiary value, right? Which is, if I say it's red and you say it's blue, well, we have a document over here that says it's green, right? That the precise terms of a verbal agreement are proved via testimony. And one thing that we know is that witnesses tend to be, more than slightly unreliable when it comes back to remembering what happened, not even a day or two ago, but a week or two or a month or two or several years ago. That witnesses are very, very unreliable when it comes to this, and so you don't necessarily want to put all of your eggs in that particular basket. Not to mention that in a lot of cases, people's memories sometimes tend to fudge based on what would have been better for them to happen, right? So people sometimes misremember events depending on what they would like to happen. So always a good idea to have a legal contract, an actual written agreement in place to sort of help you avoid that potentiality. The other real reason for it is having a document that says this agreement has defined terms and has kind of all the formality associated with it. It has a ceremonial function. It has it imparts seriousness to the process. It imparts formality to the process. It causes people to perhaps take the act of signing this document a little bit more seriously. That yes, this is the deal that we are making, right? These are the final terms of the agreement. You don't necessarily have that. If you and I just kind of make a verbal agreement, well, maybe that was an agreement in principle with the details to be negotiated out, or maybe that was meant to be truly an exclusive agreement. It doesn't really, there can be some ambiguity between those two, whereas a legally drafted written agreement will leave no room for interpretation, will leave no vagueness. There will be very clear exactly, if it's a non-binding LOI, letter of intent, it'll say that. If it's meant to be a binding contract that addresses everything, it'll say that. So again, to summarize here, the answer to the question that, the reason I made this video is I get this question from time to time, so I figure I'd sort of send people the YouTube link instead of having this conversation over and over. Is my unwritten contract enforceable? And the answer is, in many cases, it could be. But don't make it your standard business practice to go make oral agreements everywhere, and don't rely on them, because they're not the most solid thing. They're a little bit shaky. Now, can they be enforced in some circumstances? Yes. Have they been enforced in some very high-profile circumstances? Yes. Look at Pennzoil versus Texaco. Is it a good idea to rely on that as an everyday business practice? No. So, again, thank you guys for tuning in. Go ahead, like, comment, subscribe. Shoot me an email if you got any other ideas, questions, thoughts, and we'll see y'all next time.